Welcome back to the Rod Chappell Show. In our last show, we were talking about the landlord-tenant relationship and some of the things that can go wrong. As we mentioned in that segment, there are a number of issues that were brought to our attention either through Facebook or calls to us individually, and we want to talk about some of those in this follow-up segment. Again, I've got with us Brian Stumpe.
Hello, Rod. Thanks for having me back again today.
My pleasure. My pleasure. Thanks for being here. We got a lot of questions related to the last segment that we had in terms of landlord-tenant issues. Some of the issues were regarding a rent and possession concern. So we talked about there are three kinds of proceedings that can go on in a landlord-tenant action: rent and possession, eviction, and immediate eviction. Brian, the question that was at the top of my list was, in a rent and possession action, if I pay the rent at court, can I stay in the apartment?
Yes.
All right.
So if you pay the rent up, then you keep the possession in a rent possession case. So that's a misconception that a lot of people have. Well, gosh, I'm going to go there and this will happen. But it has to be paid. You can't go in there and say, I don't have it, because then they're going to get possession and a judgment for the rent.
Well, what about a promise to pay?
The promise to pay is no good. The promise was already made in the lease. You broke that promise, and they won't give it to you just based on that. The landlord could say, okay, that's fine. I'll go ahead and continue the case another time to let you pay that.
Right.
But just a promise to pay is not sufficient for the court to say, leave them in that house.
Well,
so.
And another question that I got that's kind of related, this one is clearly from a landlord. In a rent and possession action, would I be able to get my costs back for hiring a lawyer, for filing the case, and all those extra expenses that the landlord would have to go through?
Well, I would say it depends upon your lease. So sometimes in your lease there is a clause there that if legal action must be taken, the responsibility is upon the one who breached the lease to pay those types of things. General rule, you don't get attorney's fees, you don't get court costs and things like that paid. But it could be built into the contract that could allow those types of things to happen. But most likely, no, you won't get those back. And again, even if it is in the lease, it could still be discretionary for the judge to allow those or not allow those. Mm-hmm. I think your better bet is probably an unlawful detainer action if you want to get those things back than in a written possession case.
Okay. So for all the landlords out there, if you've got questions with your lease, you might have somebody review that, huh?
It might be a good thing. One question that came in to me, Rod, was about the notice issue. 30 days notice, what's that based upon? And it's based upon the term of the lease, that usually you've got to give them one rental terms notice in order to effectuate that eviction process. If you tell them on the 15th, you have 30 days until the next 15th, but the rent's due on the 1st, it's got to be a full term of the lease time in order to make that notice effective. Okay. But are there any ways? It was a further follow-up question. Are there ways to shorten that notice process? And I didn't know what your thoughts on that were.
Well, and I think that there are. Brian, as I recall, there's some case law that says that you can adjust that through your lease.
Yeah, I believe I think it's the case from the early 90s that talked about it can be shortened up to 10 days. And this was based upon a failure to pay rent. Mm-hmm. So most times they failed to pay rent in June.
Right.
Well, you give notice about it, but you can't give them the proper notice that they've got to get out until July. Mm-hmm. And that notice then is 30 days. So now they got through June, they got through July. Now in July you can finally file a case. You file the case. They have 30 days to serve the person.
Right.
And now the court case has said, if they say no, I'm good, I paid it, it gets continued for another 30 days, and all of a sudden the June payment is now all the way into September.
Wow.
And it still isn't resolved. But I believe the case you're speaking of allows them to just wait 10 days and give 10 days notice about the failure to comply in the breach of the lease if you have those specific words required by the common law in your lease.
Well, and that's what I was going to mention, Brian. As we've kind of discussed before, there are lots of nuances in this area of law as well as many others. That's going to be something that before you start just writing something down in your lease, you're going to want to consult with a professional, right?
Yeah, I mean, so often people come to me and they're like, hey, I want you to evict this person. I'm like, where's the lease? And they show it to me, and I'm like, where'd you get that lease? Well, I went online and there was a free copy. Like, well, you saved money with your free copy in the beginning, but you just lost 4 months of rent because it's going to take that long to get somebody out. And the odds are, if they're not paying you, they won't. You can get a judgment against them, but if they can't pay the judgment, all you really got is possession at that time. So it's important to be proactive. If you spent the money to go out and buy a house, to buy an apartment complex, a duplex, a fourplex, whatever, if you spent all that money, why not spend a few $100s more to go to a lawyer and have them draft you the proper lease to avoid that saving $500 here cost you $1,200 there. And if you do it 2 or 3 times, that money adds up.
Right.
If all of a sudden this happened to you, 4 times, you might have lost $4,000 or $5,000 in rent, or more than that.
Right.
With the house, you might have lost $10,000 or $12,000 in rent because you weren't proactive in looking at the lease and the proper terms to be included in the very beginning. Well,
and on the other side of that coin, Brian, what about the tenant who receives a lease from the landlord or some leasing company? Is that the kind of thing that they don't need to read, that they can just flip to the signature page and hit that signature real quick?
Well, it depends on if I'm representing the landlord or the tenant, if the answer is there. They should always read it, and they should be encouraged to read it. The problem is when you get those leases that are really long, and they're from a big rental company, well, I don't like this part. I want to scratch it out. Well, no, you can't scratch it out.
Right.
The thing to look at is, do I like this property enough that I'm willing to comply with these rules in order to live here?
Right.
And if it says no pets and you love your dog, that pet can get you, it's a material breach. It can get you kicked out of the apartment. So you've got to make sure that you're willing to comply with those issues before you sign the lease, because you're assumed to have read, to know, and to understand what's in that lease.
That's right. Now, Brian, let me ask you this, because there's another question that we received. A landlord didn't want a person to stay in an apartment because they had too many people, which that can happen, right?
Yes.
But if in this question, the concern is about 2 children living with their parents.
Well, that changes things. I think there's a lot of, and you've got to realize, an ordinance in Jefferson City might be different than an ordinance in Columbia.
Right.
In Columbia, you can have more than 4 unrelated people in the same house in an R1 unit. So it's a college town. You get 6 guys, buddies from high school. They rent a duplex or rent a house. Can't do that. It's got to limit to 4 people. Now, if there's 2 sets of brothers and 2 other people, that's okay. But otherwise, it doesn't work. But generally, children don't count. They're related to it. So you can't say, well, I'm going to rent to you. Oh, you had a child. I'm going to kick you out now because you had children. The children of the people, they're assumed to be one unit in one group of people that way. So no, just because we have some kids doesn't mean you can all of a sudden evict me for having children.
Right. And we'll just touch on this because I think that we could probably spend a couple hours talking about all the laws related to fair housing. But is it legal to, and I say is it legal, would a tenant have some rights if they were told that they can't rent or lease an apartment or building or house because of their color, sex, religion, disability, or any of those factors that have been recognized perhaps under the federal civil rights laws or state?
Well, a lot of those laws only come into play if you have more than 4 units. If you have 4 units, is it more than 4 units or 4 units or more? If you don't have enough units, the Fair Housing Act, while it's the law and you still can't discriminate, it doesn't fall under the Fair Housing Act. But no, you can't discriminate just because of someone is Jewish, is black, is blind or in a wheelchair. Those types of things are protected classes, and you can't discriminate based upon those types of things. It's a very technical law. It's more than a day's worth of reading.
Oh, absolutely.
But
absolutely.
No, you can't discriminate. But if you want to invoke the Fair Housing Act, they've got to make sure that the landlord meets the requirements to fall under the Fair Housing Act.
Right.
And I know that it's odd that you asked me that question because you know a whole lot more. That's not my forte. I've studied it, I've taken disability law and those types of things, and I understand it. But really, if someone called me with those questions, I'd say, you know what, that's great. I'll be glad to do it for you. You'll pay me a whole lot of money because it's going to take me a long time to research all the nuances, or you can save a whole lot of money and call Rod Chappell, and he'll help you out better with this than I can in the long run. So.
Well, thanks. We'll save that topic for another talk, but I did want to touch just generally on it while we were here.
Yeah, I had the same note here, the Fair Housing Act and its application. So.
Do you have any other questions that you think we ought to talk about?
One question that I got a couple times in different fashions was, can a landlord enter my apartment any time of the day without notice?
Right.
And so can they come in at 6 in the morning and walk around while I'm asleep?
No, absolutely not. Certain times there may be emergencies. If there's for example, there's a flood coming from your apartment, then maybe they'll enter on an emergency basis to fix a leak that is producing some kind of substantial damage to the apartment. In the same manner as if you would expect someone to enter an apartment or residence if there were a fire, right? But generally speaking, there's got to be some notice to the tenant. I think the acceptable notice is 24 hours.
So that's just a common question we got to ask on the Facebook about, what about this? What about that? So
That's right. Here's a question I have for you. And I think that this is a reasonable question. The way it was posed was, a person who was a tenant got sued by their landlord for failure to pay rent, right? But while that suit was going on, the landlord literally kicked them out of the property. If that person wanted to sue the landlord, should they sue them in associate circuit court, or would this be a completely different case unrelated to the, for example, rent and possession case that was pending?
Well, I guess it depends upon the basis of the kicking out and how those things happen. If the damages that you have exceed $25,000, the jurisdiction is no longer in the associate circuit court, and so you would remove that to the circuit level. But generally, I believe that in most cases, now if you invoke Fair Housing Act and punitive damage and things like that, it changes the whole dialogue again. But most times you'll file a counterclaim in the same court that the initial case came up in. One beauty of that is if you file a counterclaim with it, you're not paying the court costs.
Right.
Court costs have already been paid. You file a counterclaim, and you're going to save $164 in that filing fee. So,
well, and you don't have to worry about hiring a process server, right?
Another $35 you just saved.
You don't have to worry about the amount of time that it takes to get the issue before the court, right?
It's already started.
Right. So in some cases, it might be the easiest thing is to incorporate all the actions into one, especially since they're related.
Yeah, it's much more efficient as well that way. And the court would rather you do, let's take it all at one time than piecemeal it. If you don't raise the issue, you might lose the issue.
Right.
I mean, there's a lot of, you may have a defense, and if you fail to claim that defense early on, you might lose the ability to ever raise that defense. And so I think the counterclaim early on is the best way to do that. Now, if the counterclaim doesn't exist at the very beginning, and now they've kicked you out partway through, you didn't lose it because it wasn't there initially. You can then raise it up after it came to be.
Gotcha. Well, Brian, once again, we've exhausted the time that we have today. I want to thank our audience for joining us in this segment relating to landlord-tenant issues. And again, if you have a specific question or issue, we'll try to post some information on Facebook. There'll quickly be a Rod Chappell Facebook page up, and so look there and see if you can find the answers to your questions. And if you can't, feel free to email us on Facebook or find us on Google. And if not us, and you have a significant legal question, ask someone. Thank you for your time today.
I'm Ann Littlefield,
I'm Claudia Kehoe.
and we're here to represent the Food Bank of Central and Northeast Missouri. Over half of the Missouri students qualify for free or reduced lunches at school during the week.
But on the weekends, many children go home to empty refrigerators.
The food bank provides buddy packs, backpacks full of nutritious food, so over 6,600 hungry children have food on the weekends.
But the need is much greater. Will you help?
When you adopt a buddy, you reach out to a child in need. Your 50 cents a day will make a difference in a child's life.
Visit www.sharefoodbringhope.org or call the food bank 573-474-1020 to adopt a buddy.
Hi, welcome to the Rod Chappell Show. Thanks for joining us. Today we've got Brian Stumpe. Brian, can you introduce yourself?
Yeah, I'm Brian Stumpe. I'm the prosecutor for the City of Jefferson here in Jefferson City, Missouri. I have my own law practice and a whole stack of kids at home. So.
Hey, well, we're going to tap into your expertise as a city prosecutor, if that's all right. The theme of today's show is procedure. What happens at Jefferson City Municipal Court, procedurally speaking? Many of us have never had an opportunity to go all the way through the procedure, and I say an opportunity, it's probably one most folks would actually like to skip. But assuming that they're already there and there's an issue, from, as I understand it, it starts off in the morning and goes as late as you have to in the afternoon or early evening. Is that right?
That's correct.
Okay. And this is your second term as city prosecutor?
It is.
Okay. Okay.
I'm about 35,000 cases into it now. So
That's incredible. That's incredible. Well, we've got the right person here with us today. What happens in the morning at City Court?
Well, the first thing that we do is we have the arraignment docket at 8:30 in the morning. And basically, you go in front of the judge. Mm-hmm. The judge reads your charges to you. Rod Chappell, you've been charged with speeding 44 in a 20 in a school zone on August 5th on East Bacardi Street.
I'm sorry, by the way.
Yeah, how do you plead?
Right.
And you either plead guilty or not guilty.
Okay.
And a lot of times, the defendant want to say, well, I'm guilty, but, or, well, let me explain to you. I'm not really sure how to plead. Well, it's not the time for that.
Okay.
So the judge is merely asking you, are you guilty or are you not guilty? If you're guilty, he will assess a penalty at that time. If you're not guilty, he will then set over for a pretrial meeting where it's a court date where you come, you have a chance to talk with me about your case. Okay. We did that because we tried to alleviate the trial docket. A lot of times they want to plead guilty, mm-hmm. or they may end up pleading guilty, but they want a chance to discuss it with the prosecutor.
Sure.
And with that many cases going through there at a time, you just can't say, oh, well, once you're done with that file, bring it back over here and talk to him. There's no time to do that in the morning, so we started doing a pre-trial docket, which is a chance for the defendant to come and actually, okay, here's what's going on in the case, and kind of share their side of the story before the trial to see, well, maybe I missed something. Maybe there's a circumstance going on here. Maybe you were speeding, but you're speeding because you're taking your wife to the hospital to have a child.
Right.
Or your kid fell at the playground and you're going to pick him up.
Right.
There's things that can go on that not an excuse, but a circumstance that makes it, you know what, you're not quite as culpable because what was going on here in this situation, and it lets us talk about that.
Right.
Kind of thing. It could be a DWI, it could be an assault case, a stealing charge, a number of cases that we do down there. But after the initial arraignment, either you're guilty or not guilty, and then it goes to a pretrial docket.
Well, let me ask you, after the arraignment, where there's a guilty plea, person literally comes in and says, Judge, I'm guilty. The judge is going to assess a penalty, right?
That's correct.
And is that, if it's a speeding infraction or it's a moving violation, there's points that are going to be associated with that, right?
There will be.
Could there be a fine?
There will be a fine, yes.
Can there sometimes be jail time?
On a speeding ticket?
Well, not necessarily on a speeding ticket, but perhaps on other infractions.
Yes, for sure. Actually, every ordinance violation that we have, outside of a seatbelt ticket and a minor possession of tobacco, I think has the possibility of up to 90 days in jail. Oh. Now, if you get caught going 35 and a 30, you probably won't get 90 days in jail. It is a possibility. There's always this discretion out there, anywhere from a $0 fine to a $1,000 fine, 0 days in jail to 90 days in jail is what we can sentence you to at the city court.
Okay, okay. All right, so sorry to interrupt, but I wanted to get that out. And the other thing, though, that comes to mind is if a person were going to try to seek some advice or some help from an attorney, is there a part that you would normally, where would you expect to see the attorney involved at? Do they come in the middle, at the end, at the beginning?
Well, yes.
Okay.
So it depends on the client and when they did things. Generally speaking, they come on before the beginning.
Okay.
So you get arrested for assault, right? You bond out.
Okay.
And you have a court date in 3 weeks. Well, a lot of times before that first court date, you've already hired a lawyer. That lawyer then enters his appearance in the case. It's sent to me, and I get a special thing from the lawyer saying this person's done it. They've entered their appearance. They want discovery, and so on and so forth. At that point, I fill out the form. We send the lawyer the discovery, which is the police reports, possibly videos if we have them, just the types of things, because we want to be fair.
Right.
Oddly enough, you're not really entitled to that at the city level first time around, but we give it to you anyway because you should be able to know how to defend yourself. We want to make that open and available to you.
Right.
And so we send that to the lawyer off the bat, and then your court date would then be changed from that 8:30 morning docket to probably the next month, the second Wednesday at 1:30 in the afternoon.
Okay.
And that's where we do all the lawyer docket things at that time.
Okay.
Now we have lawyers at trials every week, but there's a special docket for people when they have lawyers for the arraignment or the pre-trial stage. That's just on Wednesday afternoons on the second Wednesday of the month.
Okay. Okay. And so I think that we were at the pre-hearing phase.
There's a pre-trial hearing that's done. It's not in front. It's not the person and myself talking to the judge. We're talking together. Just the defendant and myself. The judge doesn't know the facts, doesn't care about the facts, doesn't hear the facts unless it goes to trial.
Okay.
Or there's a plea of guilt. So until that point, the judge is kind of behind the curtain. He knows the charge, he knows when it happened, and he knows where it happened, but he doesn't know how it happened.
I see.
So the facts are not, because you don't want to prejudice the judge. You don't want the judge to, he reads the police report, well, I've already decided how I'm going to rule. No, I've got to, there could be hearsay in here, there could be things that can't come into court. It's my job to raise what I can raise. It's the defense lawyer's job to say you can't raise that, and it's the judge's job to sort it all out.
Right.
But not until the trial time. And by doing the pre-trial docket, what we found out, we cut subpoena costs and overtime costs to the city by about $60,000 a year by doing that instead of going right to trial. So it's better because the defendant feels they get a good fair shake. They get a chance to explain themselves before it goes to a trial. But the monetary savings to the community is huge.
Right.
So.
Right. That's a great change. And then after the pretrial, assuming that it's a case where that someone feels needs to go to trial, does that happen? Not necessarily the same day, but at a different point on a Wednesday.
Yeah, at that point, they'll be assigned a trial date.
Okay.
It won't be that day. It probably won't be that week, or I'm sorry, that next week. Now, if it's a vicious dog case, those are always put to the very front because the dog is being quarantined, and we don't want the dog to be quarantined for 6 weeks while we come to trial.
Oh.
Let's do it as fast as we can on the next available docket. We try and do that very quickly.
Okay.
But other cases, we're going to look at, is the officer on vacation? Is he not on vacation?
Sure.
Is he working a shift that day? So we try and schedule those dates with officer availability to say, okay, the officer's going to be here. If an officer has 4 things, let's do them all on the same day because we don't want to take them off the street. We don't want to do these other types of things. So we schedule the trial date based upon that.
Okay.
And also upon court availability. I mean, we're not going to put 70 cases on the same day. We can't get through them.
Right.
So our average docket will be between 20 and 40, which is a lot.
That is a lot.
But a lot of the cases, a defendant doesn't show up. It ends up pleading anyway, and so you never know what will happen in those situations. But it's then set for a trial docket.
Okay. Do you have a lot of people that try to represent themselves at trial?
Yes.
How does that, just ballpark speaking, how does that usually work out?
For them or for me? So it's, I forget who said it, but only a fool would hire himself as a lawyer.
Right.
Is the thing, and it's hard because when you represent yourself, you're emotionally invested.
Right.
And if you and I have a trial against each other, we're going to come in there, we're going to beat each other up for an hour,
Right.
or 2 hours, or however long the trial takes, and when it leaves, we're still friends.
Right.
That This is our job.
Yes.
I'm not attached to the underlying thing. But when it's you, if it was your son that had the trial,
Right.
there'd be a different investment that was in that for you. And so you often don't think as clearly in that situation. You want to get a different type of story out there than you would otherwise. It's the people that don't have lawyers aren't as equipped to represent themselves as lawyers are equipped to represent those people. So, but they have the exact same rights. I have an opening statement, they have an opening statement. I have direct, they have cross. I have recross if need be. I have a closing statement, they have a closing statement. They can direct examine people, they can call their witnesses, I can cross their witnesses. It's an equal thing if they have a lawyer or no lawyer. Procedurally, it's the exact same kind of thing.
Right.
But technically, you're better off having somebody know what they're doing in there than not knowing what we do there. We discussed in the previous show speeding tickets.
Right.
Well, how do you calibrate a doggone radar machine?
Right.
Well, a lot of folks don't know how to do that. They can Google it, and they might learn a lot about it, but they might miss the nuances that the lawyer knows how to do.
Right.
If it's a case where there's an assault, well, is it mutual combat? Is it under a self-defense thing? Is it a 562 exception? There's things that the lawyers want to know about that the layperson won't know about. And it's my job not to give legal advice to the defendant, not to defend the defendant, but to prosecute based upon these things.
Right.
And now, of course, if we're talking ahead of time, it's a clear case of self-defense, I'm going to recognize that, and I'm not going to prosecute you for defending yourself.
Right.
You have that full right.
Right.
But I may disagree with you. And you might be able to come in and say, well, hold on, we're going to argue this to the judge, and I want to bring up this other thing that wasn't brought up. Because if the defendant doesn't know to bring these things up to me in a discussion, we're not going to spend all day on one case in a pretrial saying, well, do you have this defense? Well, how about this defense? You're assumed to know the law.
Right.
And we're taught to say that you know the law, be you a lawyer or a layman. And so it's their job to inject these defenses.
Right.
And a lot of times the lawyer will see a defense. I mean, Daryl Driver,
Right.
passed away last year, great guy.
God bless him.
Heart of gold. That fella knew all the defenses.
Right.
He would come in and say, well, hey, Stumpy, what about this? And I'm like, well, gosh, didn't think about that one before. I mean, you want the lawyer that's there to zealously represent you and to raise the issues. And for that person, generally things go better than the person that comes in with a stack of papers from the internet and is going to try his own case based upon this, or he watched Matlock or Night Court or things like that.
Absolutely. So it's kind of a double-edged sword that the pro se person, the person that comes in trying to represent themselves, may be emotionally attached and have a different view of the facts, and may not have the expertise to actually try a case, to know the law, to know the facts of the issues that are going to be relevant and determinations that can determine whether they're fined or go to jail. Thank you for joining us today. Thank you, Brian Stumpe.
Thanks, Rod.
You're welcome.